Hello, everyone. Welcome back to another episode of the Divorce and Separation Coach podcast. Today, we're going to talk about LGBTQ plus divorce and all the challenges that come up in that specific area. The challenges with regards to surrogacy in particular, when there's questions with children, but also the overall process of divorce when you're yourself in an LGBTQ plus relationship. So to talk about this, I've invited Liza Gatrell and Gemma Davison. They're both solicitors at Stowe Family Law, and they're also both part of Stowe's modern family offering, which encompasses surrogacy, fertility, and adoption law. So true experts in the field. It's great to have you here, ladies. Thank you for joining me.
Oh, hi, Chloe. Thanks for having us.
Yeah, thank you.
So it'd be really helpful. I have to say, this is not a topic I know that much about. It'd be really helpful to understand what challenges are particular to the LGBTQ plus community when it comes to divorce.
Yeah, I think one of the challenges for LGBTQ plus couples who are going through a divorce is historically there has not been equality in this area, and society has made great changes, but the law hasn't kept up. We've now got a position where there is greater equality, but in terms of those challenges, really, I think it's firstly about finding a lawyer that really understands your circumstance and your family, and just being aware that there may be some unconscious bias in relation to that, or just a lack of understanding of what a modern family or an LGBTQ plus family looks like for people, and some of the issues that may arise. So firstly, it's finding a lawyer that really understands that dynamic and understands what you and your family need.
Yeah. Do the courts understand those challenges, or is that another dimension?
I mean, it's always a bit of a roll of the dice as to which judge you get, sort of with any case. And I suppose, unfortunately, with the judiciary, we are still in a position where there isn't really a diversity across the judiciary themselves. So, predominantly, if we look at the judiciary, and it is getting better, for example, there are more women now that sit as judges. But, predominantly, we are looking at middle-aged to older white men when it comes to the judiciary. And therefore, that will in itself potentially create bias within these cases, just from a lack of understanding, really. So there is definitely a challenge there.
And so how is the law keeping up with that to try and make sure that some of these hurdles that are specific to the LGBTQ plus community are handled going forward?
Yeah, I mean, we can talk about divorce to start with. So there have obviously been some big changes, both in relation to the divorce law and also in relation to civil partnership dissolution. And that's for everybody. So, I mean, as Gemma said, we're looking at more equality as far as the way that the law looks at these things now, in that it makes no difference whether you are in a heterosexual relationship or whether you are in a LGBTQ plus relationship. The law legally will apply the same way. And we've had some changes now. So, fortunately, we have the no-fault divorce that has come in, which is great because it's got rid of the facts that we used to have to rely on, and that in itself for this community would have created difficulties because, for example, you could cite adultery previously in relation to a heterosexual relationship, but you couldn't cite adultery in relation to a same-sex relationship, which felt very unfair. That's all now been changed because we've got rid of those, the reasons or the behaviour, if you like, that used to have to cite. So we've got the no-fault divorce, and now it works exactly the same. So it works on par, and that's the same for civil partnership dissolution as well. So we've had a change to the procedure for the civil partnership dissolution, whereby now again there's the no-fault system, and with both the divorce and the dissolution, you can now apply jointly as well as applying individually. So it feels there was a lot of work that was done by Resolution, who are family lawyers that quite often push for change as society changes. And this is one of the things that they really pushed for, that they wanted a change to the divorce laws to make it a bit more amicable. Because when we're then having conversations about children or finances, we don't want to start off on a bad foot. So we've got the no-fault divorce now. We've got the fact that it can be applied for jointly, so it doesn't have to feel like one party is petitioning against the other. There's a cooling off period, so a 20-week cooling off period. So the divorce itself, I think, works much better.
And so it sounds like the system is being I guess, made inclusive enough now that it can cover all kinds of scenarios. It's not as clearly built for heterosexual couples. And so
Yes,
the
that change. Yeah, that
sorry, go
change
ahead,
has
Gemma.
come. It's just been very. It's not come as quickly. Those changes that we now see took time, and arguably, yes, should have happened quicker. But there is now much greater equality between the two, and in the process for that divorce or dissolution of the civil partnership.
Right, so we're heading in the right direction.
Yes, slowly but surely.
That's good to hear. So I guess the part that, we all know that in a divorce, there's the divorce itself, but then there's the children matters and the financial matters. And children matters obviously come to mind in the context of LGBTQ plus divorce because there's a higher incidence of surrogacy or adoption. How do children arrangements get handled in that context, if at all differently than in a heterosexual divorce?
So if you've got a surrogacy or adoption, it's exactly the same. So if a parental order was applied for, that's the important proviso there, I suppose. If you've got your parental order in your surrogacy arrangement that's reassigned legal parentage to the intended parents, or you've got your adoption order, then they are the legal parents. So they will be treated exactly the same way as a heterosexual couple in relation to applying for child arrangements. I guess there are more difficulties because there are so many modern ways now to create a family. And, we look at known donor agreements where it may be that a friend or a family member has agreed to donate for the purposes of sort of building the family. And then we really need to get into looking at, do we have the right legal, do both of these parties that are going through the divorce, are they both legal parents? Do they both have parental responsibility? And that isn't always the case. Now, if they were married at the time that they conceived, or they were in a civil partnership, then they should both be they will both be the legal parents of the children. So that's not such an issue. It's more if they conceived potentially before they got married or before the civil partnership. It may be that we're in a situation where one of the parents is a legal parent and has parental responsibility, but the other party doesn't. Then we have to look at resolving that also within the divorce. It can just throw up all sorts of issues.
It's really about making sure that they both have all the recognition of their parents, the parental responsibility towards the children ahead of time, and then it's just the normal process of agreeing a parenting plan or child arrangement order if need be. And so with regards to the finances, is there anything specific, any specific hurdles, I guess, that come up in the context of LGBTQ plus divorce?
Previously, we had difficulties with pension providers and particularly survival benefits if one party were to die. Those changes have been brought in so that pensions can be considered same as if it was a heterosexual couple. I think sometimes what we see is slightly different in an LGBTQ situation with a same-sex couple is historically with a heterosexual couple, you may see that husbands have larger pensions because they earn more and they perhaps didn't take time out to have to care for children. But in a same-sex relationship, you may have a same-sex male couple with a dual income, both earning well, no children, and therefore the pension values are higher. And so when looking at the finances in relation to a divorce in that situation, it may be that it's more likely that we need some pension expert advice in that situation. Conversely, if you have a same-sex female couple, it may be that their pensions are lower than you would have seen in a heterosexual couple because women do still earn less, and also it depends on who's had time out to care for children and so on. So those are things to be aware of.
Yeah. You mentioned earlier the importance of having specialized support. I'm thinking even in terms of a mediator, whatever professionals come into play throughout your divorce. Is there a hub or some kind of resource that LGBTQ plus couples can tap into to find that specialized support?
There are some. Stonewall do have a list of professionals that are particularly LGBTQ plus friendly, and organisations can sign up to that. Apart from that, I think with Liza and I, it's around our own network, like what mediators we feel comfortable with that really have that understanding. If it's looking in the wider context of really specific needs, such as a child that was conceived using a donor as part in a same-sex relationship, then we have the donor conception network that we liaise with and can refer people to. And they're embarking on surrogacy, one of the not-for-profit organisations they're referred to. So there are organisations out there, and we do have a network. As I say, it is about having the right, not just the right lawyer, but as you said, the right support for your client.
Yeah, and sometimes they just have to do a bit of shopping around, like speak to a few different lawyers, speak to a few different mediators, take a look at the information that they've got on their websites, for example, and the things that they put out. You know, is there any content that's specific for this community? Because that will be a big green flag if they do.
Yeah, and then if they find one person, usually the network follows, right? I know you guys work very closely with a lot of different people who have this area of specialty, and that's usually the case. You'll be then able to tap into your own network. So it's finding that first person who can support you. But you're right, looking at websites is a really good way, by looking at the kind of articles that are being published and topics people are speaking about. That usually gives you a pretty good idea. So we've spoken exclusively at this stage about England and Wales. In my context, I work a lot with international couples. And so the question arises inevitably of the laws being different from one country to the other, in general around divorce to start with, but in particular with regards to LGBTQ plus divorce. Does a couple who's been divorced in England and Wales, an LGBTQ plus couple, how do they get their divorce recognized abroad? And what are some of the challenges with even enforcing these agreements later on?
I mean, there may be a challenge as to whether if we're looking at a country that doesn't recognise the marriage in the first place, then it may not be an issue. Like,
that's true.
The divorce itself, they may not recognise the marriage to even recognise the divorce. I think if you are in an LGBTQ plus relationship and you are embarking upon marriage and you have links with other jurisdictions, I think even before you go down the marriage route, you need to be getting advice in the other countries so that you know what the implications are. If you marry in the UK and you want to go back to live in that country or work in that country, and again, like you say, what would the implications be if you were to divorce them in the UK and then you want to travel back? And also the implications if, for example, you have property in that country, and whether you own that in one person's name or sole names, what are the implications are going to be of that? And is there anything that you can put in place to protect yourselves? We have to be somewhat careful because we can't advise in relation to laws in other jurisdictions. And so, you know, you get the typical lawyer response of, well, it depends, and maybe, you know, please do go and get advice elsewhere. But I think it's almost front loading that advice. So it's making sure that you get it if you're going through a divorce process here and there's assets abroad in a country that doesn't recognise your marriage, or you're likely to move to that country. You absolutely need to be getting advice in both jurisdictions, but also really thinking about that actually even before a marriage, if it's likely that you will return to that country or have assets there.
That's a very good point. And I can also see situations where people return to live in that country and they suddenly need to get their English orders enforced in that country abroad, which might not recognize either the marriage or the divorce. So forget about the orders. How do you deal with those kind of complexities? Are there ways around that, or do you just have to deal with the local laws?
I mean, to a certain extent, you are stuck. We don't have, the courts in the UK do not have jurisdiction to be ordering courts in other countries to be doing things, unless, of course, there are reciprocal agreements in place. So, for example, you know, when we talk about things like child abduction, there's the Hague Convention. So there's a certain number of countries that sign up to that convention. Therefore, they agree to do certain things. And there are international agreements like that regarding some things. But if you have a country that hasn't signed up to any agreements and is saying, well, we're not going to recognise it, and we're not going to consider it at all, then to a certain extent we are a little bit stuck. But it may be that there's things that we can do in this country to take effect, to take that into consideration. So, for example, if you've got a property in a country that isn't going to recognise the UK order, it may be that you factor that into the settlement, particularly if that property is in one party's sole name. So you make sure that they have that property as part of the settlement, and the other party perhaps gets more of the assets that are based in the UK. So it may be that you have to kind of play around a little bit to make it work. But it is really complicated. You would need specialist advice. It may even be that we would need to seek specialist advice from counsel as well if it was particularly complicated.
There's definitely something for people to consider then if they're thinking about moving to a country that doesn't recognize, either LGBTQ plus marriage or divorce. Something to take into consideration, because it does mean that their orders will be a lot harder to enforce locally if there was ever a problem.
Absolutely. Yeah.
So just to wrap up, I like to summarize my podcast by asking my guests to just share 3 tips. So I'll ask each of you for your 3 tips, and it's okay if they overlap. But for an LGBTQ plus couple who is about to divorce, what would be your 3 recommendations of things to be aware of? So maybe Gemma, I'll start with you.
So the first thing is, in any situation where a couple is separated, is if you can manage things in a way that is as amicable as possible, then the support network around you, divorce coaches, obviously, with mediators, and try and navigate a way forward that keeps lawyers in the background. I think that's always a good tip, to try and keep things away from court. So number 1, keep it out of court if you can. 2 would be comfortable with your support network, whether that's your lawyer or your divorce coach or mediator. You need to be sure that you can trust them and can share what is really personal, private, difficult conversations. So don't be afraid to shop around and find a lawyer that really suits you. And 3, don't be afraid to ask questions. A lot of the time it's that nobody has gone through this before. It's life-changing, huge consequences. It's extremely difficult, and we don't think our clearest when we're in a stressful situation. So just look after yourself during that and ask questions.
Yes, thank you, Gemma. Liza,
perfect. Well, I agree with all of those, obviously. To go slightly more specific then, one of the things that I suppose we haven't touched upon is the fact that where it may be significantly more expensive for LGBTQ plus parties to have children, or they may choose not to have children. I guess one of the complexities or within these types of divorces and separations can often be pets. And that's because the pets in these circumstances, as I say, if they can't have children or they've chosen not to have children, may be treated like their children within the family. And so then that can be quite a heated topic within the divorce. And actually, I think Stowe did some research a little while ago, back in 2021, and they found that 27% of divorces were now looking at pet arrangements kind of within it. So I think the advice on that would be the divorce courts treat pets the same as they treat a table and chairs. So they're treated as chattels. It's not particularly great if this is your pride and your baby, your pride and joy. So being having very open conversations throughout your relationship, and particularly if you're looking to purchase pets, trying to do it amicably, things like mediation, have those conversations. Also consider, you can have, I'm going to use the term pet nups, but prenuptial agreements that can also include like what's going to happen in relation to the pet upon divorce. So I would say, so number 1 piece of advice is, if there's pets or you're going to be having pets, think carefully about how that's going to be treated moving forwards, because you may not get the result from the court that you particularly want in those circumstances. So think very carefully. The second one would be similar to Gemma, specialist legal advice. Make sure you're well informed before you're making any decisions. And the third one would be, where you do have children, make sure that you are very clear on, are you both legal parents for the children? Do you both have parental responsibility? And if not, what are your avenues to be able to resolve that situation? Because there are things that can be done. It may be that we look at an adoption. It may be that we have to apply for a child arrangements order, parental responsibility, etc. So there are things that can be done, but you need to be very clear on, does this actually now need to be resolved? Because it may be something that hadn't been flagged up previously. And actually, I'm going to flag up a fourth one because it literally just came to my mind. Storage of embryos. It may well be that if you've either had children or you were planning to have children through fertility treatments, that you may have embryos in storage. And a question then will need to come up as to what needs to be done in relation to those embryos. And sometimes I think they get forgotten about. So just being alive to those issues would be a top tip as well.
Well, that's a good one. There was an article in the press recently around some disagreements post-divorce around who the embryos belong to and whether one of the spouses could use them. And that can be a very tricky issue. And definitely, I mean, I think what I'm hearing across all of what you're saying, both of you, is try to anticipate things as much as possible. Ask questions, say, explain your situation so that your team can advise you in the most appropriate manner to avoid having issues later on, basically.
Yeah,
brilliant.
Yeah, absolutely.
Well, thank you both very much. It was really interesting to get all this information from you both and to hear so much detail around a topic that I didn't know that much about. So thanks so much and have a great day.
Thank you.
Thank you.